This case was buried, written off, forgotten by almost everyone, until the Supreme Court suddenly brought it back to life. A gun ban nearly identical to the ones being struck down across America is now front and center before the nation's highest court. If the justices rule, this decision could either revive assault weapon bans nationwide or kill them for good. And the most shocking part, it's not new, it's a case the lower courts tried to bury years ago. Before we go further, take a moment to help keep this channel alive. Hit that like button, subscribe, and make sure your voice stays part of this fight. Because as these cases rise and fall, your engagement keeps the truth uncovered and your rights defended. The story begins in Cook County, Illinois. The nation knows it as the home of Chicago, a city that's long been a flashpoint in the war over guns, crime, and control. But Cook County's story runs deeper than statistics. It's a battlefield between two ideas: that the government can decide what's too dangerous for civilians to own, and that the Second Amendment isn't open to negotiation. For decades, Illinois has been a testing ground for gun restrictions. 2006, after the tragic shooting of a high school student named Blair Holt, local officials passed the Blair Holt assault weapons ban, a sweeping law that outlawed a long list of semi-automatic firearms, including the AR-15, and magazines holding more than 10 rounds. To gun control advocates, it was a common-sense LAW to gun owners. It was a direct attack on rights they believed were already protected by the Constitution. One plaintiff said it simply: "We're not asking for special treatment, we're asking for the same rights the Constitution already gave us." At first, few paid attention. The ban was local, limited, contained. But then came McDonald v. Chicago, 2010. The landmark Supreme Court ruling that said the Second Amendment applied not just to federal laws, but to state and local governments too. Suddenly, Cook County's ban was no longer just a local ordinance. It was a potential constitutional test case. Court challenges followed, led by Illinois gun owners and supported by groups like the Second Amendment Foundation and the Firearms Policy Coalition. They argued that the county's ban was unconstitutional, that the firearms in question were in common use, and therefore protected under the Supreme Court's Heller decision from 2008. That same principle, in common use, became the dividing line between freedom and restriction. But the Cook County courts disagreed. Judges there upheld the law, calling the weapons unusually dangerous, and claiming that banning them served a public safety purpose. And just like that, the case faded into the background. Years passed. Appeals were denied. And for most people, the Cook County gun ban became just another forgotten story, buried under new laws, new crises, and new headlines. Until now. In 2025, the Supreme Court did something few expected. It revived the Cook County case. Not because it was new, not because of political pressure, but because of something deeper, a growing legal confusion spreading through America's courts since the Bruen decision in 2022. That ruling, New York State Rifle and Pistol Association versus Bruen, completely changed how judges must analyze gun laws. No more balancing tests, no more public safety exceptions. From now on, every gun law had to pass one test. Is it consistent with the nation's historical tradition of firearm regulation? Simple words. Devastating consequences. Because when that test hit the lower courts, chaos followed. Some judges said yes, Bruen meant bans had to fall. Others said no, that Bruen didn't apply to modern weapons. And amid that chaos, the long-forgotten Cook County case began to glow again. Imagine this. A gun owner in Illinois, a 37-year-old security guard named Daniel, owns an AR-15 he's had for over a decade, uses it for sport shooting, range training, and home defense. He's never committed a crime. Never pointed it at anyone. But under the Cook County ordinance, that same rifle could make him a criminal overnight, just for crossing a county line. Now multiply Daniel's story by hundreds of thousands. From suburban homeowners to retired veterans, the question becomes real. How far can the government go before the Second Amendment stops it? So why did the Supreme Court reopen this particular case, after all these years? Because it strikes at the core conflict dividing the courts right now. In some states, like California and New York, assault weapon bans are being defended under Bruen by pointing to 18th century dangerous weapon restrictions, even though those historical examples involve cannons, not carbines. In others, like Texas and Florida, judges have said Bruen leaves no room for bans on weapons in common civilian use. That split, that legal contradiction, is precisely why the justices had to step in. Because until someone at the top draws a line, the Second Amendment means different things depending on where you live. And in America, rights aren't supposed to depend on your zip code. So what do you think? Why would the court choose this case, this moment, to make a move? Drop your thoughts in the comments, because this decision could decide the fate of gun laws not just in Cook County, but across every major city in America. For now, one thing is certain. The Supreme Court has opened the door. What comes through it could either resurrect assault weapon bans nationwide, or bury them for good. And the deeper we look into this case, the more we'll see, this isn't just about one county, or one ordinance, or even one gun. It's about the balance between power and freedom, and which one the court will choose to protect. The Cook County case wasn't supposed to return, T was supposed to stay buried, a relic of a pre-Bruen era. But when the Supreme Court changed the rules of the game in 2022, everything the lower courts once relied on crumbled. Because Bruen didn't just rewrite how gun laws are judged, it shook the entire legal foundation beneath them. And that's where this story turns from a local dispute into a national reckoning. Before Bruen, courts used a flexible test to decide gun cases. They weighed the government's interest in public safety against an individual's right to bear arms. In theory, it sounded fair, and in practice, it almost always favored the government. Judges could uphold almost any restriction if it sounded reasonable. Magazine limits? Reasonable. Assault weapon bans? Reasonable. Sensitive places, where you couldn't carry? Reasonable again. For decades, courts leaned on that word, reasonable, until one case out of New York changed everything. In 2018, two men, Robert Nash and Brandon Koch, applied for concealed carry licenses in New York. Both had clean records. Both passed background checks. But both were denied because they couldn't prove a special need to carry a gun in public. That single phrase, special need, was the spark. Their lawyers argued that the Second Amendment doesn't require citizens to justify their rights. You don't explain why you want free speech. You don't prove you need due process, or why prove you need self-defense? The case climbed its way to the Supreme Court, and when Justice Clarence Thomas delivered the majority opinion, it sent shockwaves through every courthouse in America. He wrote, "The Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home." But then came the line that changed everything. The government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. No more vague public interest balancing. From now on, the Constitution's history and tradition would be the only yardstick. Almost overnight, Bruen turned thousands of gun laws into open questions. State attorneys scrambled. Lower courts hesitated. And the Department of Justice quietly began re-evaluating how far federal gun policy could go before violating the new test. But for gun owners, and especially for groups challenging local bans, Bruen was a call to arms. They saw the chance to reopen old wounds, and Cook County's assault weapons ban was one of them. Because when you apply Bruen's history-based test to that ordinance, something becomes clear. There's no real historical precedent for banning entire classes of firearms in common civilian use. Consider a real Cook County family, the Harpers. They live in a quiet suburb near Orland Park. They're a retired police officer, his wife, and their 20-year-old daughter. 4 years, they kept 2 AR-15s locked in a safe, used only for sports shooting and home defense. Both rifles were legally purchased, registered, and responsibly owned. Then came the county ordinance. Suddenly, the same firearms they'd used safely for over a decade became illegal assault weapons. Their choices? Turn them in, move out, or risk prosecution. The daughter, who grew up learning safe handling at the range, asked her father, "How can something that was legal yesterday become criminal today?" He didn't have an answer. And that's the question now echoing in the Supreme Court chambers. The Cook County case matters because it tests the limits of Bruen. If the justices strike down the ban, it will create a domino effect, collapsing similar laws in California, New York, New Jersey, Maryland, and Connecticut. But if they uphold it, they'll carve a massive exception into Bruen, one that could allow states to redefine dangerous or unusual weapons however they choose. And that's why this case feels like a powder keg. It's not just about rifles, it's about the future meaning of the Second Amendment. Let's pause for a second. What do you think the founders would say about a law banning the most popular rifle platform in America? Would they call it reasonable or unconstitutional? Drop your thoughts in the comments, because your opinion here isn't just conversation, it's a reflection of how Americans interpret freedom in 2025. To understand how we got here, we have to rewind, to to District of Columbia versus Heller, 2008. That was the first modern case to affirm that the Second Amendment protects an individual right to own firearms for lawful purposes, especially self-defense in the home. Then, McDonald v. Chicago, 2010, extended that protection to the states, striking down local gun bans like Chicago's handgun prohibition. But even after Heller and McDonald, lower courts kept finding ways around them. They said those decisions applied to handguns, not rifles, homes, not public spaces. And that loophole created years of half measures and inconsistent rulings, until Bruen slammed the door shut. Now, for the first time in modern history, the Supreme Court is poised to revisit that logic directly, through a case born out of the very state that McDonald once reshaped, Illinois. Across the country, two different legal realities now exist side by side. In one America, judges cite Bruen to strike down gun restrictions left and right, saying the Second Amendment must be read as written. In the other, courts are stretching Bruen's historical tradition language to keep bans alive. They argue that 18th century governments restricted certain weapons, even if those weapons look nothing like today's firearms. And the Cook County case sits right in the middle of that divide. So now the stage is set. On one side, decades of legal precedent pointing toward individual rights. On the other, modern fears of violence, mass shootings, and political pressure to do something. When the Supreme Court takes up Cook County's forgotten case, they're not just ruling on an ordinance, they're ruling on the future of Bruen itself. Because if they limit Bruen now, it won't just close the door on one case. It'll redefine what bearing arms means for generations to come. And next, we'll uncover exactly how the court plans to decide who's behind the push to resurrect the case, and the political storm building just outside those marble steps. As the Cook County case made its way through the courts, it exposed a deep split across America. Not just legally, but culturally. While some saw assault weapons as symbols of mass violence, others saw them as the last line of defense against tyranny. In Cook County, local officials pushed their ban under the claim of public safety. But gun owners argued it was nothing more than political theater, targeting law-abiding citizens while criminals kept their weapons. 4 years, the case lay buried. Appeals were denied, motions ignored. And just when everyone thought it was dead, the Supreme Court suddenly brought it back. This wasn't just another appeal, it was a signal, message that the court was ready to revisit what states, cities, and lower judges had long refused to confront. Does the Second Amendment still protect the very firearms millions of Americans already own? The move sent shockwaves through the legal world. Gun rights attorneys scrambled, states braced for impact, and activists on both sides prepared for what could be a defining showdown. Because if the court rules against Cook County, every assault weapon ban in America could start to crumble, from Illinois to California. But if the court upholds it, it could open the door for a new wave of restrictions unlike anything seen in decades. The nation now stands on a knife's edge, and everyone, from gun owners to governors, is waiting to see which way the blade will fall. So here's the truth. This case isn't just about Cook County, it's about whether the government can decide what kind of tool you're allowed to defend your home with. It's about whether the phrase, "shall not be infringed," still means what the founders intended, or if modern politics can rewrite it in the name of safety. And as the Supreme Court prepares to weigh in, one question echoes louder than ever. Is the Second Amendment a relic, or a living promise? If this case falls the wrong way, assault weapon bans could surge across the country. If it falls the other way, those same laws could collapse overnight, restoring rights that millions believed were gone for good. Either way, what happens in this courtroom won't stay there. It will shape every debate, every challenge, and every headline that follows. What do you think? Should assault weapon bans stand, or fall? Drop your thoughts in the comments. Your voice isn't just part of the discussion, it's part of the history being written right now. And if you want to stay ahead of these legal battles, before they hit the headlines, hit the like button, subscribe, and turn on notifications. Because here on the Firearms Legal Desk, we break down not just what's happening, but what it means for your rights, your safety, and your freedom.